Good morning. By way of information, this is a part of the ongoing Appellate Court Legacy Project to interview those justices who have spent a number of years on the Appellate Court bench and are close to retirement or are going to remain on the Appellate Court bench forever. And today is June the 13th, 2021. We are sitting in the robing room in Riverside, California at the 4th District Court of Appeal, Division 2. And it's my pleasure this morning to be interviewing the presiding justice of Division 2, Presiding Justice Manuel Ramirez. I need to make a full disclosure that this disembodied voice is coming from retired Justice Betty Richley, who has been both a colleague and a friend of Justice Ramirez now for about 36 years. So we have a long friendship and a long history, and I'm eager and anxious to begin. Good morning, Manuel.
Betty, good morning. It's a thrill and an honor to do this for the Legacy Project, but I think it's an even bigger thrill and an honor to spend this time, this moment during the Legacy Project with you. And so I thank you for being here. I thank you for taking time from your retirement, which is, I think, a quite active retirement, as I know you and have been with you and know the particulars of that. But you mentioned that we have a unique history, and we go back to the moment in time when we were former prosecutors, you in San Bernardino County and I in Orange County. And then our time tracking from municipal court, that rare, and I think we're the last of those who have had municipal court experience, superior court experience, and then of course as colleagues on the same court for almost 20 years, if not more than 20 years on the Court of Appeal. So you're a dear colleague, a dear friend. It is why I said earlier, I'm thrilled and honored that this interview is taking place with you, conducting the question and answer session. Thank you very much, Betty, for being here.
I'm going to start with the very beginnings, like a Dickens novel, your biographical information, and basically give us a thumbnail sketch of your family history, where you grew up, your parents. I know that your father was a World War II veteran and he brought back an Italian bride. You and I share that Italian history and love of Italian food. So I'm going to let you roam for a little while in your background.
Mm-hmm. And it's a proud background, not always an easy background. Born and raised in downtown Los Angeles, and do remember well the eviction notices that were being posted in the mid-50s for the Bunker Hill redevelopment project. And as you mentioned, my dad was with the 5th Army, originally stationed in North Africa, and then redeployed with the 5th Army to Italy, into Naples, which is where he met my mom. They later his wife. They fell in love, married. And she relocated to Los Angeles, downtown Los Angeles. And after the war, my father joined her. And thereafter, I became one of 8 children, a proud Italian, Mexican-American family, growing up in downtown Los Angeles and later in the San Gabriel Valley. And not always easy, many times very difficult growing up economically. It is why I have always felt blessed to look back on my career and track it and see where I've been and where I am now. There is a story that I'm reminded of by Pericles, but maybe if we have time later on, you can jog my memory and I'll share that Pericles story with you about the funeral oration.
You are known for, in your speeches and your discussions, always referring to history and ancient history. So if I remember, we'll get back to Pericles. But now we're interested in the Ramirez story. And you grew up in the San Gabriel Valley, am I correct?
I did, yes.
And went to high school there, Mater Dei, as I recall. And isn't that where you met your wife?
Actually, I attended the old San Gabriel Mission. My children went to Mater Dei, and I think that's why it pops up into your head. Over the many years you watch all of my children grow up, and I speak dearly of the Mater Dei experience for my children sometimes as if it were my own. No, I attended San Gabriel Mission High School, the old Mission High School. It is where in my sophomore year I met my wife, Rosemary Flynn, as she was known then. And we dated throughout our sophomore year. She pretty much abandoned me, dumped me, as they would say, my junior year. And we reconnected our senior year, and we've been together ever since. We enjoyed our 52nd wedding anniversary just a few days ago. So it kind of makes this interview timely in that sense. But yeah, we've been together for 52 years, actually longer, 60 years if you include high school and college. We have 4 children, 10 grandchildren, 2 children recently born right in the middle of the COVID pandemic. So it's been an interesting past year.
You have worked all of your life. I know your childhood in many ways was very similar to mine. My father was a child of the Appalachian Mountains. My mother, a first-generation Italian-American, and they were self-made people and worked very hard and became successful. And I know you worked very hard all of your life. Where did you go to college?
Whittier College, and which, if people don't know, is the college that President Nixon attended. And if you'd like, I can sneak in just a little point of information that when the Vice President, Richard Nixon, 1952 to 1960, was active, the college was very active in awarding Nixon Scholarships to students in honor of the Vice President. He fell out of politics until 1968 when he was elected president, and the scholarship program was again re-energized. And I was, a little known fact, the very first recipient of the Richard M. Nixon Scholarship for academic excellence. And while I was very proud of the idea that I was receiving the award for academic excellence, $500 scholarship money meant a lot more to me than the award. And I have a letter from the president that sits in my chambers, framed, that I've kept all these many years.
From Whittier, you then went directly into law school?
No, actually, I stayed at Whittier to do graduate work on a teaching credential.
I did not know that.
And,
little known fact here.
It was, and I didn't finish the program. I had, I think, 4 units to go to get the credential, but in my student teaching experience, it wasn't what I thought it would be, should be. Now, you're a former teacher, so you were successful in that endeavor. I wasn't, and I immediately turned my attention to law school, and it's shortly after that I enrolled at Loyola University School of Law.
Now, at the time you were in law school, you and Rosemary were married, were you not?
We married in my senior year in college. By the time my second year of law school started, we had 2 children, good Catholics, and and for a number of other reasons, personal and medical, for Rosemary, I worked, and I did this in my time during East Los Angeles Junior College, for which I received a serious reprimand from Dean Butcher, but I either worked midnight to 8 or 7 in the morning to 3. My experience at East Los Angeles College was 7 in the morning to 3, and I would drive down Atlantic Boulevard in Los Angeles County to get to my 4 o'clock night classes, which went from 4 to 10 unless I was taking a chemistry or a biology lab, which then went from 4 to 11. And then I'd get home, and my day would start again 7 o'clock in the morning to 3 o'clock in the afternoon at Beaches Market. The schedule reversed in law school. I had to attend law school during the day, so I worked midnight to 8. And if you can imagine sitting through civil procedure after working all night, now that was a challenge.
In aisle number 4. Well, as we finish with this section on your biographical information, I think the most serious analysis we can do of that is, what impact did that have on you as you evolved, became a lawyer, then you went into the DA's office, and you're in the rest of your career? Obviously, you are a workaholic. We know that. What other kinds of influences do you think that childhood and period of development has had on you?
The desire to succeed. I have this innate sense that I'm going to fail at whatever I'm going to do. So I feel as though I have to work extremely hard to compete and to be competitive. And so the idea, if you can imagine, of 4 years in college, teaching credential experience, law school, I think that's about 7 or 8 years. There wasn't one single day off. I was either in school or working or both. And always with an eye toward there's a goal, and I needed to succeed in order to achieve that goal. But behind all of that was a failure, a fear of failure, in my chosen profession. What you know this, as former prosecutors, we'd do one jury trial, and it would be probably less than one day, and we'd wonder how we got lucky winning that case, and could we do it again? But my fear was deeper than that. I mentioned, if I may, Pericles. And having watched my father just worry and stress over having a job, not having a job, and experience that I had when I was about 8 years old, and I was on the street playing ball with one of the neighbor kids, as we always did. In those days, you could play baseball on the street. And the welfare wagon rolled up to our house, and groceries were coming into the house. It was near Christmas, and my father hadn't been working. And I ran into the house so embarrassed, and I hid. And my mother found me, and she said, "Mijo," Spanish for my son, "Mijo, it's not always going to be this way." And hard for a little kid to appreciate that or know that it's not always going to be this way, because you have no idea what the future has in store. But that wasn't something I wanted. And later, when I was in college, political philosophy class with Professor McBride, I remember the moment. We were studying Pericles' funeral oration, and he was saluting the brave soldiers who returned, and honoring the soldiers who had died in battle. And then he turned to the crowd and he said, "But we need to take care of our own, especially the women and children who have lost their loved ones in battle." And he said, by remembering them, we need to remind them that there is no shame in admitting to poverty. There is only shame in submitting to poverty. And it was at that moment, it's just like a light bulb clicked off in my head, that I realized what my mother had said. And my mother and father were incredibly hardworking. And so on and off welfare, we never accepted it as a permanent way of life. And it was that experience that just drove me to want to succeed. But it's more of a wanting to succeed out of a sense of failure, if I really was candid and truthful with you.
Well, that's an interesting insight. During this time, and as you went to law school, I know in the past, in discussions we've had, you frequently refer to some of the mentors in your life, and I'm sure growing up as you did, going to college and to law school with all of the intense pressure of having a family and having to support that family and to work, you must have had people who inspired you and who also helped you sort of see the bigger picture. And I know you've mentioned Justice Arguelles on a number of occasions. How did you meet him? And just very briefly, how did he influence you?
Well, that's an interesting story. I met him in an indirect sort of way. I had mentioned just a moment ago that I had been disciplined by the Dean of Discipline at East Los Angeles Junior College, because in my second semester, I submitted a petition for graduation. And the petition went to him, and he called me in and he said, "How can this be? You've just finished one semester, and you're in your second semester, and you're petitioning as a night student to graduate in the next semester, 3. That's unheard of, and you're a night student." So I explained to him what I had done, which was legal but funny. I enrolled in 9 units under Manuel Ramirez and 9 units under Angelo Ramirez. That's why I said earlier, middle initial A as in Angelo.
And AKA, there it is.
Exactly, common to both the 2627 North Willard address and my social security number and my parents' names. And I got a dressing down like you wouldn't believe it. And he said he had to submit the application to a committee and make them aware of what had happened. And he called me back a few weeks later. The petition was granted. I did graduate in 3 semesters night school, which he thought was astonishing. And he said, I need to introduce you to a local leader of our community. His name is John Arguelles. Here's his phone number. Call him. He'd like to talk to you. I did. And Justice Arguelles said, call me. Call me after you graduate from a real college. And I did call him after Whittier and after my teaching experience, student teaching experience turned out as it did. And he sort of encouraged me to go to law school. I met with him and at the Pomona Superior Court just to meet him. And I walked away with a number of letters of recommendation from Superior Court judges, Vogel and Justice Arguelles and a number of others. I had lunch. Here I am, a 21-year-old, having lunch with Superior Court judges in Pomona just to meet somebody and walking away with all these letters of recommendation. And he has been with me in my life from the day that I made that phone call in 1969 to the present.
Goodness.
And he's now 94. And I do my best to see him once a month for lunch. We meet and we talk about a lot of things, including you, Betty.
Oh, well, I hope it's all good things.
It is all good things.
Were there any other people in law school, particularly any of your teachers that you felt kind of influenced you in some way, either what would later become your legal philosophy, your judicial philosophy, or your work ethic? Of course, you didn't need anyone to mentor you in that. That sort of, you're such a self-starter. But can you think of anyone in law school that inspired you?
No, not really. I didn't have, circumstances were such that I didn't have time for socializing, either with students, fellow students, or with teachers. I did attempt at various times to see some teachers about what can I do to make sure I succeed in this class or that class. But my memories of people who pushed me along in life, and I have been blessed in ways that people just can't imagine. From my first grade teacher, Mrs. Mitchell, coming to my house in Rosemead and telling my father, your son needs to speak English. And I remember that. I remember her at the front door, very prim, very proper, 1955. And there weren't English as a second language programs. To working at night, my first Social Security contribution took place in 1960, working for Joe and Beverly Schwartz at the liquor store. And Joe telling me, hey kid, you need to go to college. He says, you don't want to be like me. And yet I saw him as a businessman and successful. And he would refer to his brother Max as a very successful pharmacist. And it was the first idea or notion that was put into my head about going to college. And here I am, 11 years old, 12 years old, working there at 10 o'clock at night. And Beverly, his wife, would come into the store about 10 to 10, just prior to closing, with her most scrumptious, delicious pound cake and a big mug of coffee, heavy on sugar and cream. And I would sit there on a milk crate with Joe, and we'd be talking, and he'd always refer to me as, hey kid. Roger Gunston I worked with at Beaches Market when I was struggling with chemistry, and he was a UCLA law student at the time. And he actually took 3 successive weekends to work with me on chemistry classes and lessons. And I'm to this day believe that had I not had the benefit of those private session moments with him, I probably would not have passed. I passed with a B+ in chemistry, by the way, but for Roger's experience. And so even Bernard Butcher, the scolding, Dean Butcher was a big man, 6'4", 300 pounds. And when he came around his desk, he scared the hell out of me, but he gave me a huge hug. So all of those special moments, I think, just continued to catapult me into life. So it was those moments and the idea that I didn't want to fail for fear that I would disappoint them.
In law school, after you graduated, what led you to the district attorney's office? Because I believe you went directly to the district attorney's office from law school.
That wasn't always my intention. I interviewed with the public defender's office, and I failed, apparently. I never received a job offer. And there's another person that special in my life, a very, very famous prosecutor, Oretta Sears, who argued cases before the U.S. Supreme Court, the California Supreme Court, the Chamel case, within arm's reach search and seizure case, Theodore versus Frank, the search warrant case before the California Supreme Court. And as I walked out of the elevator on the very first floor of the courthouse in downtown Santa Ana, I almost knocked her over, a tiny, petite little lady carrying a lot of files. And she could tell that I was upset and angry. And she turned to me, she goes, "Young man, why are you so angry? Why are you so upset?" And I thought, it's a pretty remarkable observation that she made. And I explained to her what had just happened. And
your interview with the public defender.
Yes, the interview with the public defender's office that didn't go so well. And she said, "Well, how would you like to interview with the district attorney's office?" And I said, "I'd be excited to do that." And she goes, "Maybe you'd make a better prosecutor than a deputy public defender." And with that, we proceeded to go to the other end of the building in Santa Ana, and she provided an interview. And it was the most unusual interview. Bill Evans, Maury Evans, John Conley, and a couple of others, Mike Capizzi, were in the interview room. And they wanted to know about, well, you played football in high school, you played baseball, you're a pretty good athlete. Would you join the DA's athletic team? I said, absolutely. And that's how I got my position as a district attorney. I love that experience. That was probably, just as your experience was, one of life's great moments.
Well, I think from my experience, I know in talking with you, I think one of the things that we all remember fondly is that there's such a team spirit in we can only speak from the prosecutorial offices, but in those offices, and a sense of collegiality. And do you think that your sense, and I know how important collegiality is to you, and we'll talk about that in depth a little later, but do you think that, never having been a lawyer before and worked in a legal office, that the foundations for your respect for that characteristic later on as a judicial officer was born in the DA's office?
Absolutely, absolutely. My experience is just as identical to yours, I think. That out of a sense of teamwork, common goals, a desire to make right via the victim, the law, that sense of collegiality, esprit de corps, and that idea of playing ball on the baseball team or the basketball team, it carried into the office.
It became a family.
It did, and it didn't matter that you were or weren't on one of those teams. In the office, it's as if we were a team, and we were. And so whether it was running down in the middle of a trial saying, "I need a case, someone help," they would jump in, or conversely, if somebody was in trial and he had more cases than he could handle calling ready, someone would walk around the building and grab you. "What are you looking at, Ramirez?" "I'm getting ready for a trial for next week." He said, "Well, let's do a trial this week. Let's walk and talk." That was the famous DA's phrase. All of us as DAs used to hear that. And we didn't hesitate because we knew out of that team spirit and esprit de corps, collegiality, that by taking that without a heads-up warning, that case, we were helping a colleague, but more importantly, we were getting into a courtroom for a victim and prosecuting a case on behalf of a victim. And that was a very rewarding and enriching experience, all in all.
I know, and we'll talk a little later. On the appellate bench, you were and are well known for the intensity of your community outreach program. Do you think, having been in the district attorney's office, where you work with the victims of crime and their families, that also may have had an influence on your later appreciation and the need for community outreach on the appellate court?
No, absolutely. Again, and that outreach in the district attorney's office was on different levels. There was the outreach to victims, of course, and later as you and I were prosecutors in the 70s, and victims' rights weren't paramount at the time, but we were prosecutors long enough to see that victims' rights became critical, very important to our society. And so I participated in a number of victims' rights promotional activities through the DA's office, the last being the vertical sexual assault program, and dealing with the families whose spouses or children were molested, some very, very violently. But we also did outreach with law enforcement. By training, I was head of the North Orange County Drug Task Force, so meeting with the chiefs, meeting with the various drug task force officers, some incredibly talented and dedicated law enforcement officers, which makes it for me a little bit difficult seeing what's going on in today's society. But we outreached in a number of different levels, as I'm sure you did. It wasn't just victims, but it was across the board a community outreach on a number of different levels.
Yeah. Did you have any inkling as you spent your time in the DA's office, and you were there how long? 6 years, 7 years?
Almost 7.5 years.
Yeah. Any inkling at all that you would ever end up as a judge?
No.
At
none.
any level?
None. And of course, at that time, as you recall, as we've discussed, there was a municipal court level, superior court level, and beyond. But no, I never thought of being a judge for a couple of reasons. I didn't know any politician. I didn't know the governor. And number one, and that was just a very remote idea. But number two, with the last name Ramirez at the time, that's the last thing I wanted. My sense of running a judicial campaign and the last name Ramirez, which back then, it's hard to imagine that now, wasn't a name that I thought might be accepted by the voters as someone deserving of their vote. So no, I wasn't going to. I enjoyed being in the DA's office. It was going to be a career and a damn good career.
So how is it that you jumped that gap or bridged that gap?
You really want to know?
Yes. I hear a story coming
There
on.
is a story. I was sitting in my office in the district attorney's office, not far from the district attorney, Cecil Hicks. By the time that I was in the vertical sexual assault prosecution unit, we were an elite unit equal to the homicide unit, so we had the best offices, which meant we were the closest to the boss, and he was a wonderful boss. So he wanders into my office one day and he said, "Manuel, how would you like to be a judge?" And I said, "Boss, that sounds like a nice idea, but it's not really for me. I'm looking forward to my next assignment." And I wanted to be a head of court. And at the time, I was the assistant head of court. And so I explained to him why, and he seemed to understand. That was in August of 83. And he came back in early November, and he said, I think you should submit your application, and let's get you going on that. And I said, no, I've seen that from other colleagues, and it looks like a chore. I don't have time for that. And he said, no, you should submit one. It would be a good idea. I was so naive. I wasn't really reading between the lines. I didn't submit one. And right after Thanksgiving, he came in and he said, if you want to continue your employment with this office, you need to submit the application. So I want to continue, so let me submit. What harm can there come? Well, I went through the process, and it was a short time thereafter that I was appointed to the bench. But I really was concerned about a retention or an election. The only other Hispanic judge appointed to municipal court was defeated in an election, and that was my concern. But I had enough friends and colleagues and people in the law enforcement community who said, look, we'll help you with a campaign if it comes to that.
Nobody ever opposed you on any of your positions?
No, in municipal court, superior court, no one. So I continue to be, as I said earlier, the most blessed person on the face of this earth. I believe that. Another mentor would be Cecil Hicks.
Do you feel that your later years in the DA's office and as you went into the municipal court, I know you referred to your naivety, and I can identify with that in terms of what is involved in the process of applying for a judgeship and who you have to talk to and the steps you have to go through, which is personally something I disliked. I know you disliked that. But do you feel that it, in some way, helped evolve what would become your judicial philosophy?
It did. It did. And each time I raised my right hand, the oath of office, the words, and combine that with, and it's not to say that deputy public defenders, defense counsel, don't abide by the same rules. They do. But to me personally, the idea of the rule of law and the oath of office were paramount. And I didn't see any difference between following the rule of law and the oath of office as a prosecutor and or as a judge. To me, they were the same. They were compatible. And I dare say, had I been a defense attorney, it still would have been the same. It is the same for any attorney who takes the oath of office as a new attorney. And I have been presiding over the swearing in of new lawyers since 1991. I haven't missed one of those, and to me, I haven't. I take it as a personal obligation on honor, even though it almost always falls on an anniversary date. And my poor wife has always been very understanding about working our anniversary around any June oath of office ceremony. But it's the rule of law and the oath of office that I found to be one and the same. In many ways, it made that part of responsibility and duty easier to accept as a judge because it was very similar, very identical to being a DA, an attorney. You
mentioned you've not missed one of the swearing-ins at the Court of Appeal, and I might reiterate, you have now served over 31 years at the Court of Appeal. So that's 3 decades of swearing in new lawyers through the state bar to the state of California.
Can you imagine the number of attorneys?
I don't, but do you have statistics on that?
I really don't, but I know it's in the thousands.
Yeah.
And I talked to them about Abraham Lincoln's experience as a lawyer representing a lawyer who was going to be disbarred. But that sometimes strikes me as the wrong tone, a bit negative. So it depends on my mood, but I rarely use that one. However, I do exhort those young men and women who will become new lawyers to the words of the parable of the 3 stonemasons, which I know you know that parable, and the bar card that they receive is similar in symbolically to a stone. A block of stone, and I say, if I were to give you the stone as the stonemasons received, and asked you just as they were asked in the parable, what would you do with this stone? The first stonemason would say, well, I'm going to earn a living, and that's good. Lawyers earn good living. The second stonemason responded by saying, no, I'm going to shape a beautiful pattern with this stone. So that means you did more than just generate income. You had a nice career. But it's the third stonemason in that parable that is vital, important, and has the vision. Because when she is given that stone, she responds first by looking up to the sky, and then to answering the question by saying, with this, I will build a cathedral. And I exhort lawyers to take their bar card and with that bar card, build a cathedral with their career. It's how they will be remembered as lawyers, and they do that by participating in bar activities and all the things that would just make them that kind of a lawyer. So I have always drawn inspiration, I think in part why I do that, from those events.
Do you believe that, again, we're talking about influences and philosophy, with that philosophy as you stepped up on the bench, that feeling intensified in terms of your view of the law as Muni Court and Superior Court judges, we're in the trenches. And the appellate court, we're not in rarefied air, but we realize that we are writing, and it's creating a legacy of the law, so to speak. And do you believe that, again, that affected, as you got on the appellate court, that affected honed your judicial philosophy in any way?
To a certain extent, and yes, I realize the value of an opinion, published or unpublished, and the need for clarity. I have always, in my discussions with my staff, mentioned to them that it is by way of an opinion that we're speaking to the trial judge, we're speaking with the trial attorneys in the immediate case, and then to a broader audience. And so we need to provide clarity and direction and guidance. But all of those life's experiences sort of allowed me to focus on that goal, that objective. I don't know that I've accomplished that. I'd like to think so. I try. I have had some cases that, a couple that stand out in my mind about the tension in wanting to uphold the rule of law, and when is it appropriate to do a concurrence or to do a dissent. And that comes with great responsibility, I think. And that so happened in two cases, as I recall, and I didn't have time this morning to review either one of them, but People versus Burks and People versus Brooks, the former examining the notion of lesser included offenses. And it was just an unusual burglary case where the defendant was caught inside, and as a matter of law, I didn't feel that he was entitled to any lesser related or lesser included, and he had the goods in his hand when he was caught inside. So it was all or nothing. And I remember the Cedeno case, People versus Cedeno. You need some evidence in order to merit a lesser included, a lesser related. And so I wrote a dissent, and the Supreme Court granted review, and the Supreme Court overruled many of the aspects of the underlying Geiger case. And in Brooks dealt with the first case on threats, the words, and whether or not they're protected by the Constitution. And that was an interesting case, and the Supreme Court has followed that case in many of its published opinions. One was in 1992 and one was 1994, so the earlier decisions. But they weren't easy cases because you want to sort of follow the body of law that exists. We're obligated under auto equity, and a sense of, now I'm kind of departing from that to say this. Very uncomfortable, inconsistent with my very strong sense of the rule of law and my obligation under the oath.
Do you think, having served roughly 4 years on the municipal court, you were on the Superior Court 3 years, I think, then elevated to the appellate court, that those trial court experiences, being in the trenches, everything that you think about in context of being a trial judge, was a detriment to you or a benefit or both as you started your work on the Court of Appeal?
Oh my, this is probably the easiest question you've asked all morning. It was a huge benefit.
Why?
It was a huge benefit. Starting first with municipal court, as you may remember, we weren't one assignment judges. We would start our courts at 8:30 or 9 o'clock in the morning with perhaps traffic tickets. All the judges would divide those cases up amongst themselves. Then we'd had landlord-tenant cases, and then we would have small claims cases of sorts. And then by 10, we were expected to do our misdemeanor jury trials. And back in those days, just as when we were DAs, the DAs were knocking at the door wanting to try cases. And so we'd be doing under the influence of heroin, Health and Safety Code Section 11550, the 23102 vehicle code violations and the petty theft, the solicitation, prostitution cases, the 647B. And that exposure to the public in the court, the exposure to all of those lawyers. Same with Superior Court. You and I both handled heavy duty civil, criminal, complex civil litigation, calendars, and so all of that added to our sense of what a judge does, what his or her responsibilities are, caseloads, and equally important, the need to make a decision as quickly as possible. Sometimes I know that I'm perceived as wanting to make a decision too soon. But if that's a criticism, well-founded or not, I don't know, but motivates me is knowing that in a criminal case, if we find error, it lets the defendant know that there's error in his case is going back to the courtroom. It lets the people know that if there's error, they're going to have to retry this and they need to gather up their witnesses and their case. If not, and it's affirmed, then the defendant knows, well, this is where my future, and he may have other avenues. In civil cases, the litigants are accumulating interest. If it's that kind of a case, daily, it's expensive. And they need to know they're getting their money now or they're not, or it's going back for trial. So all of the earlier experiences, I think, in many ways, drive me to make a decision and move cases. When you and I started at this court, I don't know if you remember, I would attend national presiding justice conferences, still do. We were the second slowest court of appeal in the entire country, from notice of appeal to an opinion. In our time together, we went from that to, I think, the third fastest in the country. And there should be an asterisk to the third fastest or fourth fastest, I don't remember. And that asterisk should be that we were the per justice opinion writing heaviest court of appeal at that time in the entire country. So you remember well, I think it's either 1999 or 2000, we decided more than 1,200 cases, and there were just 6 of us. But we all came from a background where we knew we had to make decisions, and we knew we had to work hard at doing that, and we did. And my colleagues then, like you, would always say, I think we can handle more cases, send them. And I think that's our obligation to the litigants, decide these cases quickly, intelligently, logically, and consistent with the rule of law and our oath. You did that. I'd like to think that I've done that.
Don't you think, though, also having been on the trial court, you get a sense of the weight and worthiness of a case in terms of the legal issues, and so you know what cases are going to require more effort, more time, what cases should be prioritized, cases that the rule of law is pretty apparent, the facts are pretty easy, you can push those through cases through the system faster. Do you feel that you've done a good job in terms of being the administrator of the court in making that assessment?
I do, and that behind the scenes assessment back then and to this day drove me to look at, even though we had limited resources, whether it's per justice, per attorney, per clerk, per judicial assistant, are there alternative ways or methods or manners in which we can handle our caseload given the limited resources? And so we just enjoyed our 30th anniversary of the all-volunteer mediation program.
And you, I think, were the first justice in the state, presiding justice, to initiate such a program at the appellate level.
At the appellate level, all volunteer attorneys.
Yeah.
Yes, and in fact, we'll take it a step farther, the entire country. And I communicated that in my letters to the chief very recently in honor or in celebration of Law Day. And what is amazing about that program, is that program started in 1992, continues on to this day. The incredible men and women, it's what I love about our profession. The lawyers who are so dedicated. The men and women in San Bernardino County and in Riverside County who to this day volunteer their time and their services to mediate cases. Some of the ugliest cases that we've ever seen go through our mediation program and settle. We have one lawyer that I'm aware of that's participated in almost 40 mediations and settled 26 or 28 of those cases. One of which that mediator carried in her caseload, our caseload, for over a year. It was a very hotly debated, disputed property issue and parcels of property amongst family members. And after a year of just dragging that case through the system, it settled, it received finality, and it received a conclusion that we could never have achieved with an opinion. That's the beauty of the program. So 1,400, 1,500 cases settled, hundreds and hundreds of millions of dollars in savings to the taxpayers, all of the briefing and record preparation and decisions by the court and return to the trial court and the appellate court, all just disappear, fall by the wayside. And so hundreds of millions of dollars. And so when we may not get those cases out as quickly as I would like via the internal operating procedure of the court, those cases are decided by mediation from some fabulously dedicated and talented lawyers in our profession.
Well, when you came to the Court of Appeal, you came as the presiding justice for the Court of Appeal, which means you administer everything that goes on in this court. How have you met that challenge?
I think it was difficult at first. One of my colleagues, and I loved him dearly. You knew him. I think you felt the same. We just had utmost respect. Justice McDaniel would take me to bar events, Rotary Club events, outreach, as we were doing it then, and introduce me as someone younger than his grandson. And I had to sort of work through that sense of being so young. And I was, and I always felt uncomfortable about that. I felt that the better path, if there was going to be one to the Court of Appeal, would be a few more years of seizing at the Superior Court. And those are not decisions that we get to make, and we don't call out those career paths. They're done by somebody else. And so working through the idea of being so young and working very hard at trying to reach out to the bar associations back then, Ken Gluby, San Bernardino Bar Association, Kurt Seidler, the Riverside Bar Association president, and working with them and through them to go out and meet the various members of law of our profession, and meeting with the public defenders and the district attorneys in both counties. It was something that I felt I had to do just to create my bona fides, so to speak, get my feet wet or on firm ground, and with law enforcement. I always considered it one of the great honors that I've enjoyed when I had law enforcement call me to deliver academy commencement speeches, which I did so for a number of years. And so all of that, I think, is in that mix of that question you asked.
Well, I was looking at the list in preparing for this interview, and I was amazed of the things that you have done as the presiding justices of this court, the programs that you've initiated, and I'm just going to list some of them. You developed a historical oral argument. Tell us about that.
Well, it's a continuation of outreach, but a different kind of outreach, and a kind of outreach that I thought was appropriate for appellate court. And so I thought we should start with the Karamatsu case, a case that deserved to be out in the public arena. And I remember a couple of my colleagues thinking, you have to be crazy, this is just a horrible case. The support that we received from the public when we announced that event was beyond what I ever could have imagined. And we combined every one of those outreach programs with a cultural program. So We coordinated with the cultural artwork that we positioned throughout the courthouse. We ran videos throughout the courthouse of historic events that led up to that moment. And we invited people who actually experienced those things, including, as you and I know, a colleague that just passed away,
Judge Kayashima.
Ben Kayashima, and he spoke. And I think of him, and I think of that moment in time, because one of our colleagues, it might have been you, Betty, asked, well, what was your experience there as a 6-year-old in
he was at Manzanar, I believe.
He was at Manzanar. And he said, my experience was remarkable. He said, I had the world's largest sandbox and kids to play with. Now, that is his experience compared to that of those, the parents, which is far different. But so from that one, as we worked down through the years, and the last one that we did, I am working on the next one, but I can't reveal it until I can get more detail. But the last one, the 75th anniversary, I think, 70th anniversary of the Holocaust event. And we had World War II memorabilia all over the building. We had the video with Elizabeth Taylor doing the documentary. It was an Academy Award-winning documentary. We had members from the Simon Wiesenthal Museum here. We had Holocaust victim survivors, if I'm using that word correctly, that phrase correctly. Outreach was incredible. People into the building. We had more people requesting to be in the building than we had seats available.
Yeah, we recreated it, as I recall, from the bench. It was a full bench of everyone here at the court, and the legal arguments that were made in terms of Nuremberg, and with Karamatsu, of course, the arguments that went up to the Supreme Court. So it was a semi-recreation from a legal perspective of what happened in those cases, but you provided the context around which those legal issues fomented.
Well, and yes, and let's not forget Brown versus Board of Education. We
Yes,
had the
that's
entire
right.
Brown Foundation
That's
from
correct.
Kansas was in our court, and the artwork that they provided. And we did the Mendez case, which is really the foundation for the Brown versus Board of
yes.
Education, because that case was being litigated in the 40s. I think it was decided in 47. Sitting at the counsel table as amicus counsel was none other than a future U.S. Supreme Court justice who would argue the case to the U.S. Supreme Court, Thurgood Marshall. And we had lawyers from Erwin Chemerinsky, Dean Eastman, lawyers from large law firms who would argue these cases, and they would all ask me the same thing. Don't put me on the government side. No one wanted to be on the government side in the Brown case, or in Mendez, or in Karamatsu. And on one of those cases, sidebar comment made by, I think it was Dean Eastman, who said, Erwin, I think I'm going to win this one. and Erwin says, no, they're not going to change the opinion. And so they have been incredibly moving experiences. To this day, I read from time to time the remarks that were delivered by the Holocaust victim survivor. And it just brings a tear to my eye.
That was an incredibly poignant experience, I think, for everybody in the courtroom, to have those people here who are now no longer with us.
Yes.
And that, as I said, the historical oral outreach, very successful. I don't think any other court has done that. And
recall that we had a prisoner uniform that was brought in by the surviving victim, Holocaust victim survivor, but it was her husband's uniform, and we put it on a mannequin, and it stood in the lobby. And all of these historic oral argument cases can be found in volumes in the CalApp reports.
Other things you've done, we've talked about settlement conference, we've talked about the historical oral argument, the court outreach program, whereby the court goes to high schools in the area and literally hold a session of the appellate court. And those require a lot of coordination, a lot of effort, a lot of work. And also, I think, meeting with the high school students, so we always met with the students beforehand, had coffee and pastries with them, and got to talk to them. Just very good memories I have of those experiences. And the other thing, of course, is you're one of the few justices in the state of California. You built the courthouse.
I did.
The very courthouse we are sitting in.
I did. But just to go back to that moment about those cases, the hardest part of the outreach program, and I think you and I probably have somewhere between 10 and 15,000 high school students that we've delivered oral argument to. But the hardest part of that job was finding appropriate cases that the principals would approve, because they didn't want outraged parents. And so some of the cases that we thought criminal were very interesting, a little bit too gory or beyond what they wanted their students to hear. But no, the building experience for me was, again, one of those hugely unexpected blessings, an experience I never thought I would have. But we were in the old Safeco Title Insurance building, as you know. And
in San Bernardino, we would watch the rats in the alleyway.
We did that, and you're going to be interviewing Justice McKinster in a few minutes, but we would race some of the largest cockroaches. And he'd take the one on the left, I'd take the one on the right, and doggone it, he always picked a winner and get to the lunchroom before the other did. But we had the best air conditioning system in the dead of winter.
Yes.
And we had the best heating system in the dead of summer, where often from May to September it was 105 degrees, and it was just brutal. But there were a lot of other things that were wrong with that building. It just didn't uphold the sense of dignity and decorum for a court of appeal. So I started lobbying way back in '92 with our local leaders. It was Bob Presley, Bill Leonard, a number of others. Endless numbers of meeting mayors. And it wasn't until 1996 that somebody, I think, just finally gave up and said, okay, Ramirez, we'll let you build this building. And the state gave us $7 million to do a 42,500 square foot building, and said, this is it, no cost overruns. You want it, you build it. And then we found out there was no process. There was no process for taking requests for qualifications, for bids, for how we could carry the money over from one year to the other. And we had to work through a process, and we did. Back in those days, it was with what was called AOC, the Administrative Office of the Courts. And you and Jim Ward and Bart Gott and Art McKinster and Tom, we were just so fixated on getting that goal and completed and walking into the building. 16 months was our timeline. We walked into this building in 15 months and returned about $30 million, I think. No, it was more than that. Three. The budget was $7 million. We closed in on the building at 6.7. So the balance.
$300,000.
We returned $300,000 to the state. The state had no idea what to do with that money, by the way. And we walked into what I consider still to be, if not the most beautiful court of appeal, one of the most beautiful court of appeal. Certainly the best cost per square foot at $7 million of any building in the state of California.
Well, one of the things that you initiated, which was near and dear to my heart, and I was able to participate in, I almost considered myself a beneficiary of the program, is you worked with the two clubs in Los Angeles, the California Club and
the
Jonathan Art Foundation. The foundations, I collect plein air paintings, so they have the largest repository, private repository, other than the Irvine collection of plein air paintings. And you were able to work with them, and they provided the artwork. In fact, we're sitting here, I think over your shoulder is part of the photographic artwork that is on loan to us. They take all the responsibility, the insurance responsibility, they come out, they set it in place. You have originated, and we would participate in sort of a docent, when people are coming into the court, we show them the art, and it has now been in practice how many years?
Oh my gosh, more than 20 years.
And we got to pick. They would offer us, what do you want in your chambers? And so each of us, and it reflected our interests. I remember Jim Ward had a seascape, a ship in his chambers.
He did.
I had a plein air painting. And so it was just of such great benefit to us personally, but also to the court and to the public.
We do. We open the court to tours to any group that would like to take a tour of the building. We've probably done in excess of 125 tours in the building. Small groups, large groups. Whenever there's a new Rotary Club membership group, the 8, 10, 15, 20 of them will call and say, we want to take our newest members through the building. It is part of yet another outreach program that we have. But I'll never forget the day that I mentioned to you and Jim, because you were the two that I ran into at first, to mention to them that we've been called by the Jonathan Art Foundation to come down to the Jonathan Art Club and view the artwork to be selected for our building. We were stunned and shocked. Took a lot of meetings and negotiations and discussions prior to that moment. And when we walked into that club on the 5th floor, and the artwork was leaning up against the walls of their holding areas, we were all ecstatic, and we immediately knew which artwork we wanted. You're right, Jim took the World War II famous Victory at Sea battleship large painting, and we have these. But what was more interesting was that once that word got out, there were several other foundations that asked, can we hang our artwork in your building? So to this day, I've lost track, shame on me, 5, 6, or 7 different foundations with artwork that they've displayed in this building.
And not
to this
one
day.
dime of expense to the state of California.
Not a penny.
It's just
Not a dime,
been a
not a penny.
terrific program.
The public enrichment is tremendous.
Yeah, it's been an amazing benefit to the state and to the court. And to the colleagues of mine who have these paintings in their chambers. I mean, to come into your chambers and see a piece of art that you love
And it's
is so enriching.
that you love, and that's world class. It's a unique. So it's again a special blessing.
Having traversed 38 years on the bench, 31 of which have been spent at the Court of Appeal, the obvious question is, what, if any, changes have you seen in the demand on the court, and this is a multiplex question, you may want to write this down, in the attitude of the public toward the court, if you have any sense of that, and in the attitude of the attorneys who practice before the court?
I have said over the many years that I've been here, early on and recently and in between, that we have a remarkable group of men and women as lawyers, both in the building, our staff, and of course your question is directed to those who appear before this court. Talented, smart, dedicated, a huge majority. Every once in a while you'll get someone who's a little bit different, but by and large, the lawyers that appear before this court from all over the country, locally and far away, talented, smart, dedicated, and want to promote the rule of law on behalf of their clients. And so the biggest change has been in the past year, in which we've done remote oral argument by way of the Blue Jeans software program. And yet again, those lawyers quickly adapted to whatever initial hardships there were in getting on board with the Blue Jeans software program. But we often have lawyers appearing from all over the country, San Francisco, certainly San Diego, and the savings to them by arguing their case in their office is recognized, and on behalf of their clients. I'm not sure I'm going to get them back into the courtroom. We are, and they will, because they're just that way.
Do you see a sort of I don't want to call it a conflict, but a tension? You built a beautiful courthouse here. The state built a beautiful courthouse. The taxpayers paid for a beautiful courthouse. There seems to be, maybe this is old school, a sense of a benefit to having the lawyers come into court to argue their cases versus sitting in their sweats with their suit ties on and their suits and their ties on, but they're wearing jeans and sweats in their living rooms. Do you see this as a positive change for the court? Because once we're in, it seems to me we're disappearing perhaps down a rabbit hole of technology. Is there any sense of what might not be accomplished by that?
I am old. You said old school. I am old. And the fear of that continuing is real. I can't deny that. But the benefit of appearing in person, where the lawyer can look you right in the eye and make his best, most sincere, powerful argument, is different than appearing on a camera. The lawyers, our lawyers know that. We know that. And so, but I think that once we get well beyond the pandemic and its effects, people will settle down and return into the courtrooms, where I think they really want to be. They want to come into the courtroom. They want to see justice.
Doesn't it affect, the public image of the courts, because they're not going to come down here to watch Zoom?
Exactly. And so they want to come in and they want to see the justices. The public has a general interest in a particular case or all of the cases, be it criminal or civil. They want to see the justices. They want to see the reaction of the justices. Each justice has a different personality. Some are very active on the bench. Some are less active. They want to see that. They want to see that interplay. There's a dynamic there. They want to see the lawyers and how the lawyers challenge politely, respectfully, the viewpoints expressed by the justices. But I think also just as important, and perhaps even a bit more powerful, is this court, unlike any other court in the country, and we do many things that courts in the country do not do. We issue a tentative opinion. And that tentative opinion is given to them 6 weeks prior to oral argument. And so they can come in and make a very powerful or persuasive or hope to convince us otherwise of what we have put into our tentative opinion. And while they can still do that by way of the Blue Jeans software program, that sort of in the penumbras of oral argument, to use that word, is lost in the penumbras that you make in person. The in-person argument is powerful, it's direct, it's seeing the justice eyeball to eyeball. And I think lawyers want that as well. We want that. And so sometime when this is over, perhaps at the beginning of 2021, we will return to a normal courtroom format.
Do you believe the tentative opinion program, I've only ever worked for 20 years under that protocol. I've never understood why it hasn't spread to other courts. It seems to me that it is more effective, more efficient. We know that the lawyers prefer it. Do you believe that the effect of the protocols established by COVID-19 may prompt a change in other courts now to a tentative opinion program?
I would like to think so, but I have to say I'm really biased about that because, like you, I've only worked in the tentative opinion program venue or court. I think there are so many benefits to the tentative opinion program. The cost benefit to client. They have the tentative in a civil case, for example. Call the client and say, listen, this case is a ruling against us. The firm has researched it. The court's correct. You can have us go to oral argument, but it's going to cost you X dollars. We're going to do this, and we're going to prepare. There's a cost factor, but if we submit, the court's given us the option to submit waive oral argument, and submit it. We will save you $10,000, $15,000, $20,000. On the other hand, if there really is a point that needs to be made, the point can be made more persuasively and more powerfully because they can come into the courtroom, they have their 15 minutes, and they can say, Your Honor, this is right here, page 7, line 3, where we disagree with the court's reasoning.
Yeah, not a shotgun approach.
And let us tell you, as opposed to taking a snippet here and a snippet there, and hoping that one of the snippets will hit line 3 on page 7, when often it doesn't. And that is the benefit to the tentative opinion program. But I've never promoted the tentative opinion to other courts or courts of appeal, simply because I'm respectful of their internal operating procedures and practices. But I'm like you, rather puzzled why it isn't a program that is adopted by more. But that's for them to decide, not me.
I know you work very closely with your attorneys in your chamber specifically, and with the principal attorney here. And I know you, and I know you would like to give a shout out to some people. And here's your opportunity to do that.
Thank you. Recently retired managing attorney, someone I worked with day in and day out, as I do with the current managing attorney.
For almost how many years? 30 years?
31 years, Don Davio. And Susan Strebel, I now work with daily on a number of court projects and issues. And you had a remarkable staff.
I did.
You loved working with your staff, as I did. And most justices develop a bond with staff. You can't be with somebody day in, day out, and as you have this sense of respect and admiration. And I would say small a affection for them as well, because you recognize day in, day out how dedicated and hardworking they are. And so over the years, I've had outstanding staff, people that have great admiration for Nancy Smoke, and currently Donna Hecht, your former attorneys, and Carmela Simoncini, and Lisa, the judicial assistant. And Margaret Ann, as I referred to her, was my judicial assistant secretary back as they were known in those days. She was pretty remarkable, and many other staff members that I've worked with, central staff and others, many who have retired. Little known fact, with the exception of just maybe a small handful of people here, I have hired everybody. I've hired most all of the attorneys in this building. I've hired most of all of the clerical staff in this building. The smart ones, they all retired after 20 years. I'm the only one hanging around. But the benefit is I can look back and think fondly of those. Paula Garcia, Henry Espinoza, the two clerks. Andy Smith, the current clerk. Incredibly talented. Interesting lady. She came on board in 1993. A year later, I presided over the wedding ceremony for her and her husband. And she was the lowest level male file clerk in the building who rose to become the clerk of our court. Remarkable success story there.
Well, the qualities that you look for in staff, and particularly the attorneys, seem to have worked out well, because many of them are, unlike the federal courts, the research attorneys here remain with the court.
And I haven't done that at all, but a huge shout out to the settlement conference coordinator, Jackie Hoare.
Yeah.
Now Jackie came in as a assistant to the principal at a local grammar school, and both Henry and Don thought, no, she doesn't have the qualifications or the ability to be a settlement conference coordinator. And that was a position that didn't exist in California until I went to the administrative office of the courts. We created the position. She filled it, and she is the unifying force and it continued day in, day out inspiration for the success of that program. I'll say, Jackie, this case looks like the lawyers might be on their own working on mediation. Can you give them a call, see if they need our assistance, or just by virtue of the call, that'll inspire them to settle more quickly, or settle on their own without court assistance. And we have that sort of flexible relationship, but all of the work that she does for the court through that program is beyond what is expected of the job. But that's typical in this building. Everybody works very, very hard to do more than their fair share of work. So I'm very proud of just to be associated with these men and women.
Almost 40 years on the bench. What changes, you could write a thesis on this, but changes you're witnessing in society over the years, attitudes towards the law, towards judges, towards the Court of Appeal. What are your thoughts about that?
I think across the board, loss of civility and respect for institutions. We're all seeing that. You are everyone, we're all seeing that. Rude folks on the freeway, shootings on freeway, at will, criminal activity. And we want to think it's unique to this era, this point in time. And I don't know how close we are to finishing, but there is a conversation that takes place with Roger Roper, and I know the lawyer for the ages, can't think of his name, Thomas More. And Thomas More knows he's going to go to the guillotine, and his son-in-law Roger Roper tells him,
Well, the
look,
axe, actually, yeah.
the axe. He was going to lose his head. And Roger Roper says, basically, give him what he wants, referring to the king. And Thomas More says, look, if you cut down all the laws to accomplish your goal, when they come for you, what will you do? You will have no law to protect you. It is in part why I think he was the lawyer of the millennium lawyer. He had such a passion for the rule of law and his oath. He was an office holder. And I see that sort of eroding. Local politicians who take the oath on Monday and on Tuesday say, I'm not going to follow that law. I think there's an equity argument. Well, it's not for them to make the equity arguments, for them to follow the rule of law. There are venues for where equity can be resolved, and I may be saying something that's controversial, but a society that is founded on civilized behavior, respect for the rule of law, it promotes economic activity, it promotes a safe society, all of the things that go with that. And I'm seeing that change dramatically, and I'm not happy with that.
Do you think that is one of the greatest challenges that the courts and the institutions of justice face?
It is. We'll issue orders, and it remains to be seen if those orders will be followed. On the Court of Appeal, we're all fond, you were too, of citing auto equity. The Supreme Court says this is the holding, this is the rule of law. We know we must follow that. Now we can say in our own sort of way, we kind of think a better approach would be this, or we kind of disagree, but in the end, I will follow.
It's up to the legislature to change it.
Yes, and if the governor has a program, then he needs to work in tandem with the legislature, but it isn't for the branch. And I sometimes think that the public thinks that the judicial branch can provide equity where the legislature and the governor don't, and that's just not our role.
Do you see a tendency more recently in the last 5 or 6 years for constitutional issues being raised in cases?
No,
or not?
Yeah, no, more or less. I think that's a fairly constant, thriving area that's been there. I think it seems like it is more just because we have so much media and day-to-day coverage and right down to the last minute moment, breaking news everywhere. And it seems like it's more, but I don't know. I don't think so, though.
What do you think have been the rewards and advantages of your career?
Advantages. I've had the good fortune of meeting remarkable people, private sector, public sector. I've never shared this with anybody. Just one little tiny morsel of your question. Years ago, I was asked by a governor to head up the Judicial Selection Committee. And when that governor's term ended after 8 years, and I was great respect for that governor, notwithstanding all the criticism that that governor has received over time. And the governor who followed in his footsteps. I had, again, the very good fortune of being the chair of the Judicial Selection Advisory Committee. And I can reveal, if you want, with your permission, that you and I were on that committee. I was the
Yes,
chair, and we
for a
worked.
long time.
We met once a month, and just so that people understand what we did and how we did what we did, because it's important.
I know that we kept that. Per the governor's office, they wanted that to be kept confidential, and all of the years of service. I'm sitting here. This is the first time that you and I have publicly acknowledged we were on that committee, and it was a long time.
It was we never acknowledged, and I don't think anybody knew.
Yeah, nobody knew. We wanted it that way also.
We did, and we worked in a better environment
Yes.
with that level of secrecy. We looked at applicants. We never cared. I don't recall anyone in our committee of 6 or 7 ever saying, well, this person's a Republican and this person's a Democrat.
Never.
Or this person's background is this or that. There was a time when we were doing what we were doing. The entire bench in San Bernardino and Riverside had turned over, and we were responsible for those judges that were elected, for those judges being appointed to the trial courts. But it was always with an eye toward, and this is how we opened, an eye toward looking at those potential soon-to-be judges. Did they have an understanding from what we had, information we had in front of us, that they could follow the rule of law and that they would be faithful to their oath of office? And we didn't care if they were Republican or Democrat or independent or anything else. And we had a high expectation, because of the huge volume of cases in this jurisdiction, that they were hardworking men and women. They weren't going to leave the bench at 11 o'clock in the morning and go play golf. They were going to work hard. And I think you would join me in saying that of all those people that were appointed, now there may be 1 or 2 that didn't meet that ultimately, but I can't recall any.
And ultimately, it was the governor's choice.
It was the governor's choice. We were forwarding the information, but every one of them, talented, smart, hardworking, irrespective of their politics.
Yeah.
Very proud of that fact, as you were too.
Yes. Is there anything now, 40 years later, briefly, that you might do differently? That's an unfair question to throw at you at the end of this interview. But
I don't think so. Except I regret that I didn't push, and I pushed at the time very, very hard. I was passionate and intense. I probably would have pushed for a bigger building.
I knew it.
We're out of space. We have a building with 8 justices, and every chambers is occupied. Every attorney office is occupied. We have one attorney office not occupied by an attorney, but a clerk, because we don't have any room for that clerk who handles confidential matters. So I sometimes consider that to be a failure. On the other hand, I'm not sure my $7 million and leftover of $300,000 would have gotten us even one additional chambers. But I sort of consider that to be a failure of process and what could I have done better. But no, I have no regrets. I continue to feel I am as blessed as anyone has ever been to have ended up at this position, in this chair with you, with a lot of special colleagues that I've worked with, bar associations that I have great admiration for, and the men and women of our profession. So I'm blessed, I'm lucky.
Well, we will close out our interview on those very positive words, and thank you very much for your candor and openness, and for asking me to conduct the interview. I really enjoyed this.
My pleasure and my honor to be with my former dear, wonderful special colleague, Betty Richley. Thank you, Betty. Thank you.